And we're live. Hi, I'm a former military attorney, and I am going to explain the fork in the road email that was sent to all the federal government employees. And I'm also going to break down the lawsuit. So there's currently a lawsuit pending that is challenging that offer of a deferred resignation. And so we're going to go through the lawsuit and I'll break it down and explain it. So, just a little background while I'm bringing up the lawsuit. So, in let's see if I can make it smaller. So, um, in this, the what happened when Trump took over and was sworn in on January 20th. Um, he had obviously had campaigned with Elon Musk. Elon Musk talked about reducing the size of the government, and essentially that's what they've done. So when Elon Musk took over Twitter, famously he sent out an email with the subject line "fork in the road." And in that email, he explained that all of the Twitter employees were to return to the office, that there was going to be no more remote work and no more telework. And then the fork in the road email essentially said, if you don't want to come back, if you don't want to come back into the office, or if you want to stay where you're at your remote location, then you can resign. And there was, I believe, a severance package. All right, so that works for the private sector. Things are really, really, really different for the private sector or for the public sector. So for federal government employees, completely different ballgame. There's a lot of laws that apply, and public sector employees are unionized. And so once the Trump administration took over, there were several EOs that were signed immediately. One of them was to cancel remote work and telework for federal employees. And then when that was done, there was also emails that were sent out through OPM, which OPM is Office of Personnel Management. It's essentially HR for the federal government. And initial emails were sent out to just kind of test it, to see that all federal employees were included and could see the emails. And then once that testing was completed, then an email with the subject line "fork in the road" was sent out. So very, very similar to what happened when Elon Musk took over Twitter. Now, when the emails went out initially, a lot of employees thought it was fake, like spam. They didn't know what was going on. Once it was validated that it was real, then the fork in the road email went out. And when it was initially went out, there wasn't a whole lot of information. And so when it was sent out, essentially it said that the employees could have a deferred resignation if they didn't want to come back from remote work or have in person 5 days a week. And so they could just reply to the email and with the response, resign. Now, there was a whole lot of unanswered questions, a lot of issues with that. So there were some FAQs that had been put out, and those FAQs have at times been giving conflicting guidance. The guidance isn't, from my perspective as a former military attorney, I did labor and employment law for about 4 years, didn't necessarily comply with the law. And so the public sector labor unions got a huge volume of employees asking about the offer, trying to get an answer about it. And so then they filed a lawsuit. So that was earlier this week. So that I'm going to share that lawsuit. All right. And so this is a lawsuit. So it was filed on February 4th, 2025, and it was filed in the District Court of Massachusetts. And so it would these are the plaintiffs for the lawsuit. And so it's in federal district court. So that means no cameras will not be live streamed. So it's the American Federation of Government Employees. That is the largest public sector union that represents a vast majority of federal employees, and then a local union in Massachusetts, and an American Federation of State, County, and Municipal Employees. And then it is the defendant in this lawsuit is OPM, which is Office of Personal Management. Like I explained, they're essentially um, HR for the federal government. Let me see if I can do this a little bit better. Just share my screen. Okay, so I think, let's see. I think that's a lot better. Okay, so like I said, this is the lawsuit. And so it's a complaint for declaratory and injunctive relief. So, what does that mean? So, declaratory relief means that they just want the court to declare that something is unlawful. And in this case, because it's an administrative agency, they want it to be declared that it violated the Administrative Procedures Act, the APA, that it was arbitrary and capricious, which is essentially the standard. So, federal agencies cannot act in a manner that's arbitrary and capricious, and if they do so, it violates the Administrative Procedures Act. They also are asking for injunctive release. Now, an injunction was granted in this case. But it's for a limited time. So, I tried to download the order for that injunction, but it wasn't available on Pacer, which is the record systems for the federal court systems. So it was kind of surprising that it wasn't available. But um, there's an injunction that's currently in place, and it will be until the hearing is on Monday. So OPM, Doge, who's ever running OPM right now, there's been some reports that the normal people who run OPM have been locked out of the building, and the Doge team has taken over. And so they sent out an email recently that this offer, the fork in the road email, the deferred resignation, has been extended until Monday evening. So there is a hearing on Monday, so we'll see what happens. All right, so let's get into this lawsuit. And so the initial fork in the road email was sent on January 28th. And so I heard a lot of reports in the media about it being that essentially it's like a buyout program. It really isn't. So it is a deferred resignation, which means an employee, if they say, hey, I want to take part of this program, they're not resigning until the very end of the fiscal year, which is the end of September of this year. And so they're just notifying OPM, HR, and their supervisor that I am planning on resigning, but they will stay a federal employee until that resignation, until the end of the fiscal year. And so it's not a buyout. They're just still an employee. So that they're still going to get paid. They're still going to get benefits, everything, accrue leave, etc. However, the supervisors are encouraged to place these employees on administrative leave during the resignation period, from the time that they opt into the program until their resignation is effective, and they can always choose to have it effective earlier than the end of the fiscal year, but that's the longest that they are given. And so it's not a buyout, it's not a severance. They're still a federal government employee, still subject to uh, the legal restrictions that federal employees are subject to ethical restrictions. And so they're still employees, and it's up to the agency whether to place them on administrative leave or not. So it's not a guarantee that they're going to be on administrative leave. And so this lawsuit kind of explains that. And so I'll just go through and highlight some important parts. Um, and so it's talking about, hey, this is potentially a problem to the government if employees if they leave in large numbers. That a lot of this career civil servants, they have the subject matter experts, they are the continuity, and so the government would lose a lot of qualified employees, and essentially the kind of what has been discussed is that any employee who opts into this program, likely their job is just going to get cut. So they won't be replaced. And most federal agencies do have a hiring freeze, anyways. So the agency couldn't hire someone to take their place. And while they're still an employee and their resignation isn't finalized, you couldn't hire against that authorization either. So um, and there's been some other moves based on some other executive orders that they are going to expand employees um, who are essentially considered political appointees, and then they can be fired with no notice. And so this lawsuit kind of talks a little bit about that. And so, talking about the executive orders, the administration in its first 2 weeks is purported to wipe away longstanding civil service protections and merit system principles mandated by Congress with stroke of a pen. Not quite, but there is some moves that would make a lot of civil service employees at will. So currently, the Supreme Court has interpreted the right to property to also include your federal job. And so, because of that, you have a right to due process. So, once you become an employee, now that's after completing a probationary period, generally a year. Then a federal employee, they're considered a statutory employee and they have rights. So, particularly notice, they have to be notified of the termination, the reason for the termination, given the evidence that the termination is based on, and given an opportunity to respond, usually 30 days. So, but it kind of depends on the union contract. And so this is talking about there is some move to make more federal employees at will instead of statutory employees that would get that notice and due process rights. All right. So, so this lawsuit lays out, goes through the facts. So in federal court, they do what's called notice pleading. That means you have to put the other party on notice as to the allegations of the lawsuit and explain the facts behind those allegations. And so in this case, they're discussing that deferred resignation fork in the road email. And so it was sent out on January 28th. And there is a copy on the internet that you could go to read that email. But essentially, like I said, they're not resigning now. So that they are just saying, hey, I'm opting into this program, but it's actually a deferred resignation. So even this lawsuit is kind of, it's not congruent. And so it is a deferred resignation. And so there is even a template deferred resignation letter that the employee can give to their supervisor. And it says, I am not resigning until, the end of the fiscal year, until the end of September of this year. And so, yeah, employees were given a little bit more than a week until February 6th. And so, like I said, because of this lawsuit, that has been extended currently until Monday. So I believe February 10th to accept or reject the offer. I believe about 60,000 employees, give or take, have accepted it, which means it's about less than 2% of the federal government civil servants. And I believe it's about 6% attrition rate a year. So not as many. And you'll see throughout this lawsuit, it explains the unions are encouraging their employees not to take this deferred resignation. So the unions are counseling their the employees not to take the deal. So that could be another big reason why the numbers are pretty low. All right, and so this lawsuit talks about how several of the employees are concerned about whether or not, essentially, is this legal? Can they do it? They're concerned whether it can honor the deal, and I'm going to explain that this argument doesn't hold water, and so I'll explain this. There's also been a lot of questions about whether they can continue, whether they can look for outside employment. So, can they look for outside employment now? So, Elon Musk has actually tweeted, yes, they can go get another job. There's been some in the FAQs saying, yes, you can go get another job. But what it fails to consider is that there are ethical restraints and statutory restraints. So, there's laws that prohibit federal employees from doing certain jobs while they're a federal employee. And so, like I said, this is a deferred resignation. They're still federal employees. And so they wouldn't be allowed to, for example, they can't go work another federal job, obviously, right? So they can't double dip. They can't get two federal jobs. They cannot go work for a government contractor. So they can do some behind the scenes work for a government contractor, but they cannot represent back to the federal government. And what does that mean? So that's a federal criminal statute. It's 18 USC 205. And that says that essentially they can't work in the federal workplace. That would be representing the contractor to the government. But the Government Ethics Office, the OGC, Office of Government Ethics, have interpreted this representation to essentially mean that even working on projects, so not at the government work site, not in the federal building, but if working for that contractor, but working on a project that involves a government contract, that would be representing to the government. Also, for like attorneys or anyone representing people for VA claims, Social Security claims, representing those individuals in front of the government would violate this criminal statute. And so there are some very hefty, and these are, like I said, criminal statutes. So there's a very big concern about what jobs the federal employees, if they take this deal, can take or not. And so they are somewhat limited. Also, there are other ethical regulations that say that you can't work an outside job while you're supposed to be on government time. Now, technically, those requirements could potentially be waived. They're federal regulations. They could be waived by the executive branch. But as far as I know, they're still in place. And so then, I mean, questions about pension, healthcare, not really, because they're still employed. Again, remember, they're still employed. And so, and then there's also, there's threatened about restructuring, realignments, reduction in force. Absolutely. So the administration has been pretty clear. There are going to be reductions in force. These are called RIFs. They happened a lot in the 90s. They're going to happen now. And when a RIF happens, it just means like an entire category or an entire division or an entire, group of employees are laid off. And they actually have no due process rights when a RIF happens because it's nothing personal. You had nothing to do. It's just we're eliminating maybe this entire division or this entire agency. An entire agency could be taken away, reduced, and then all their employees are going to be laid off. And so that's part of the questions that the union has been getting. And so their argument is that this is arbitrary and capricious in a number of respects. And so I'm going to read these. Let's highlight because this is an important part of the lawsuit. And so, yeah, that they, oh, what happened? There we go. All right. Now I lost it. Okay. So that it's arbitrary and capricious. Remember, I explained that that's the standard under the Administrative Procedures Act. If it's arbitrary and capricious, the courts could strike this down if the court finds it's arbitrary and capricious. So this is the crux of the argument. One, that it fails to consider possible adverse consequences of the directive provided to millions of federal employees to the continuing function of the government. Yeah, I agree with that. I think that there's a lot of issues with this kind of blanket, let the employees decide whether they want to um, quit or not. So I use this as an example is at military hospitals. So my son, I was in the military when my son was born, and he was in the NICU after he was born. And if it weren't for those nurses at the NICU, I mean, I don't know. I mean, they saved his life. The doctors and the nurses at the NICU saved his life, but they were all civilians. So none of them are military. There was a military hospital, but all of them were civilians. And so they all got that email. So what if NICU nurses decided, you know what? I'm burnt out. I'm going to take this deal. I'm going to defer resignation. So what, I mean, how do we staff the NICU? And so that's really the problem with this idea to just let the kind of employees decide, because entire offices, entire divisions, entire um, groups that provide important services, I would say, right? NICU, important. I'm sure you could think of several other examples that they could essentially cause mission failure by opting into this. And the lawsuit will explain, and I'll explain how it was done in the 90s and how it was done differently, and how that was really a better way than what they're doing right now. It offers conflicting information about employees' rights and obligations if they accept the offer. I would agree with that. There has been conflicting information put out with multiple different versions of the FAQs. It runs counter to longstanding rules and requirements for federal employees. Absolutely. Never been done before, totally unprecedented. And as I'll explain, there is precedent for what has been done, and it's not this fork in the road email. Contrary to reasoned practice of government restructuring, yes, absolutely. It's allowing kind of employees to determine what should be cut in the government instead of allowing agency heads to decide, what divisions to keep or what divisions to get rid of. Ignores history and practices around effective workplace reductions. Yeah, like I said, this has been done in the 90s. There were lots of rifts in the 90s, so it's been done. Arbitrarily sets a short deadline. Yeah, absolutely. So, I mean, it seemed to be an arbitrary deadline that has been extended. Pretext for removing and replacing workers on ideologic basics. Yes. So I think the thought process behind it, hey, if you don't want to come to work 5 days a week, or if you don't want to move from your remote location, you can take this deal and see yourself out. So we're not going to fire you. But this is a way to get rid of you anyways. All right. Contrary to law, there's no statutory basis in an unprecedented offer. Yep, I would agree with that. Absolutely. All right, now here is where the argument really falls apart. So it talks about the most current appropriation for most federal agencies expire on March 14th. That's correct. So the federal government is currently under what's a CR, a continuing resolution. That means Congress didn't pass a budget. They're supposed to pass what's called annual appropriations. So that means they give money to government agencies, federal or executive branch agencies for usually 1 year. And so they are supposed to pass these annual appropriations every year in the fall prior to the end of the fiscal year, which is the end of the fiscal year is 30 September. And so Congress didn't do that. So to avoid a government shutdown, they passed what's called a continuing resolution. So the continuing resolution just keeps spending at the same levels, the same appropriation that was the year prior, and it keeps it at that same level. And then another CR was passed in December. Again, they wanted to avoid a government shutdown right before Christmas. And so Thomas Massey called it out long before it happened. Back actually last spring, said this is what's going to happen. They're going to have a CR until about Christmas, and they're going to tug at everyone's heartstrings. We can't close the government, and so they're going to have. So then they're going to pass another CR, and so that's what they did. And so that funding expires March 14th, and so they're claiming this purports to make or authorize an expenditure and obligation through the 30th, that's the end of the fiscal year, before the appropriation and authorize the Anti-Deficiency Act forbids such guarantee. Now, the Anti-Deficiency Act does prohibit the government, the federal executive branch, to make authorizations or expenditures in advance of, that's before an obligate or an appropriation. So that would be in advance of. But this is where the argument totally falls flat, because they are still employees. So that it's not an ADA violation to have continued employment. So that this is where this argument, I don't know who the lawyers were on this lawsuit, but if it were me, I would never made this argument, because it absolutely falls flat. All right. So just talks about the plaintiffs representing more than 800,000 federal civil servants. Again, I think the federal government has about 2 million employees. And then no military members, completely exempt from this. Has nothing to do with military members. We're just talking about civilian employees. All right. Plaintiffs have spent a lot of time and resources counseling employees to explain what's going on. Makes sense. Says it's arbitrary and capricious, contrary to law, and asks for the court to declare the directive as issued arbitrary, capricious, not according to law, vacate and remand the directive to OPM to provide a reasoned basis for the directive and extend the deadline accordingly. And so that's what they're asking for. And so they did get, like I said, they did get that injunction. So until there's a hearing on February 10th. All right. So then the lawsuit just explains the parties. And you can find this lawsuit, actually, if you just Google for it, you can find it. So AFGE posted it on their website. So that's where I got this. All right, so this just goes through the federal union. All right, so that explains the plaintiffs. All right, jurisdiction and venue. So like I said, this is in the federal district court in Massachusetts. They chose Massachusetts because they had this local AFGE local that's from the district. All right. And so the legal framework, it's talking about the APA. So this is what I explained. The Administrative Procedures Act a court can hold unlawful and set aside agency action found to be arbitrary, capricious, abuse of discretion, or otherwise not in accordance with the law. And so that's what they're asking for. They're wanting the judge to say that this violates the APA, and so it needs to be either enjoined or given an extended deadline. I believe they're going to make the argument on Monday that they want maybe like a 2-month deadline to allow employees extra time to consider it. All right. So again, I'm not going to belabor this, but this argument absolutely falls flat. It is kind of a garbage argument because again, they're employees. They're still employed. So I'm not going to get into that argument because it's kind of worthless. All right. So it goes in the allegations. It talks about the fork in the road email. It talks about what went out, that you can just email resign. but then your workload, you're going to be exempt from all in-person work, and your workload, you should be placed on administrative leave. But again, like I said, it's going to be up to the agency. So some agencies have already asked for exemption for this. Some entire employees have been exempted, national security roles, postal service, military members, they're all exempted from this. I believe the IRS is asking for exemptions for this. And so it just goes in and explains this. Yeah, implicit threats of earlier termination. So it does. There are some discussion in the FAQs that are like, hey, cuts are coming. This is kind of the best deal you're going to get. So you should take it. All right. The directive itself said that majority of federal agencies likely to be downsized. Yeah, they did explain military branches may increase in size, but most agencies are going to downsize. All right, so they see that as kind of a threat against future employment. All right, and then OPM did not conduct any analysis of what agencies would be likely to experience high level of resignation, optimal number of resignations, or where the staffing was already insufficient, that soliciting resignations would cause harm to government operations. That's what I was talking about. So that's what I was explaining, that kind of like put it in the hands of the employee versus the head of the agency, probably not the best person to determine, which employees are necessary to operations or which are not. And particularly if you're already suffering from, insufficient employees, if you're already in an office or in a division that's undermanned, people are going to be burnt out. They're doing all the work. And so maybe they'll take it. And then who's there to do the work? Like no one. All right. And so like, for example, like the VA, I think the VA actually got a blanket exemption from this because of the severe shortage in VA facilities. And so I'm going to find in this lawsuit where it talks about, or like, oh yeah, this is a good example that they explained. So air traffic controllers received this email, even as an OPM official told that air traffic controllers were exempt from the program. So there's, like I said, lots of conflicting guidance. All right, no advance warning. There's no plan, no analysis. And so let's see. It's just kind of in a blanketed fashion. Yeah, overwhelming blanket fashion without any targeted or analysis. And so let me see where it talks about what happened in the 90s. So I'm going to get into what they did in the 90s. So during the Clinton administration, there was a big reduction of government workforce, a lot of rifts. And essentially, they came in and found out that this is about the federal job. They came in and found that, hey, there's a lot of like mid-level managers, right? Yeah, still true today. And so they decided that they would find ways to, yeah, here it is. Okay, so in the mid 90s, they would find ways to reduce the size of the workforce, improve efficiencies. And so they had a task force to kind of information, figure out, where to have the cuts. And they actually had Congress passed a law that allowed a one-time payment as essentially a severance package for $25,000. And so those were actual buyouts for those federal government employees. And so, yeah, the offers were designed to reduce unproductive layers of management, with 70% of the buyouts coming from managerial employees. And so it was a reduction of more than 100 government employees. And so, but it was, within a year time frame, and they got congressional authorization. So kind of the big difference between what happened in the 90s and what is happening now. So in the 90s, over a year, kind of targeted buyouts. They were actual buyouts and getting severance package versus just a delayed resignation. Congress approved it, so Congress passed laws to allow the buyout. So this is, you could look up the law. This was the authority that gave the $25,000. And so OPM made kind of strategic plans. The agencies went through and kind of determined, like, where can we cut and where should we cut, and then those were given the buyouts or the RIFs. And so the argument in this lawsuit is saying that, hey, this is how it was done historically. This is how it was done legally. There was no issues with this, but how it's being done now is totally arbitrary, like absolutely arbitrary. And let's go back to the part where they talk about taking a different job. So yeah. So let's see. Yeah, so it fails to adequately explain how it's consistent with longstanding ethics rules concerning outside employment. So, like I explained earlier, so there's a lot of rules, not only ethics rules, but also a federal criminal statute that really restricts federal employees as to what they can do for that second job. And so the part of the FAQs that I was talking about said, absolutely, we encourage you to go find a job in the private sector. But none of the FAQs explain the limitations on taking a private job, particularly the criminal statute that some employees may not be aware of and may not understand, that they can't take a job with a contractor and then go work on government contracts or work in the federal workplace. And that is a criminal statute that can't be waived by the executive branch. All right. Prohibition on dual pay. So like I said, they can't go get like another federal job. Then it says if they resign, it does not affect their ability to work for the federal government. But I'm going to tell you, future government employee or the employees that stay, they're going to know, hey, if you left around this time, they're going to pretty much assume that you're an employee that took this deferred resignation, and likely it's going to give you a black mark for future government employment. And so, yeah, it says blanket assertion that all federal employees who accept the deferred resignation can absolutely obtain a second job are incorrect. And I agree. I think that there's a whole lot of caveats about what that second job can look like. And again, I think ethics rules will have to be waived by the president in order to allow employees to absolutely get a second job. All right. And then, yep. So it talks about, they think that this fork in the road is coming from the same thing from Elon Musk. Yep, absolutely. All right. That the deadline's arbitrary. Yeah, like I said, I think that they're going to be asking for a 2-month extension on that deadline when they argue this case on Monday in front of the judge. All right. All right, then they kind of make it political. I'm not going to get into the politics of it. All right. So again, they're talking about the Anti-Deficiency Act. I think this argument absolutely falls flat and definitely is not a good argument at all. And so I think it's kind of a garbage argument. So let's go through the rest of it. Let's see. All right. So yeah, these are just more going through the FAQs. And like I said, you can find the FAQs online on the OPM's website. So you can, and again, there's been multiple FAQs pushed out, and based on my reading of them, they do conflict at times. So there was concern about like the government shutdown. So again, they're still going to be employed. So they would be furloughed, just like most employees in the event of a government shutdown, and then likely receive back pay. So Congress has always um, paid employees, even the employees furloughed who aren't working, they've still always gotten back pay. So Congress has always included that furlough. All right. Let's see. It says that plaintiffs have been harmed. They have to plead some sort of harm for standing. So they're saying, like, hey, we've spent a lot of money, we've spent a lot of time with our employees, trying to work through this and advise them on. All right. And they're going to continue expanding resources to deal with these emails. And it also impedes the plaintiff's ability to perform their mission. So since they're getting challenging, not enough information, conflicting information, it's been really difficult for the unions to advise. And so that they're again pleading some harm. All right. So, and then this is their claims for relief. So, again, like I said earlier, they want to have this act declared arbitrary and capricious. And this is what they're explaining, kind of just an overview of what they've already argued. And then here's the request for relief. So, they want it to declare that it violates the APA, vacate and remand back to OPM. They want to go back to the drawing board, OPM, figure out, maybe look to the 90s, do what they did in the 90s and do that. They also want to enjoin OPM from this offer, from implementing this offer until they can have legal justification or adequate legal assurances of the terms. And so we'll see what happens as a result of the hearing on Monday, and we'll see what the parties argue. And then, yeah, I'll definitely have another live stream breaking down the post hearing, what's happening. And they also want plaintiffs' attorneys' fees, of course, and then any other relief that the court deems appropriate. All right. And so, yeah, there's the 60 days. So they're asking for the deadline to be held in abeyance for at least 60 days. So that was the 2 months that I was saying that they're going to argue at the hearing on Monday. And all right, I'm going to stop sharing my screen. And they're going to argue for an extension from if the court is going to hold the fork in the road, the deferred resignation valid, that they want at least 2 months to be able to adequately explain all the consequences of it to their members, to the employees. I know that non-supervisor employees, so eligible bargaining union members, so they don't have to be dues paying members to avail themselves of the resources of the union. So even employees who, as long as they're eligible to join the union, even if they don't pay dues, even if they're not technically a union member, they can still get advice and representation from the union. And so the union does have a kind of a heavy lift to explain that to all their employees. All right. Well, if you have any questions, please leave a comment. You can also reach me at militarylawtalks@pm.me. And so you can email me there, or you can leave a comment. And if you got any value out of this video, please like, share, and subscribe. And I'll see you next time.